Hindu Adoption and Maintenance Act 1956. All you need to know about adoption and maintenance under Hindu law. Introduction. Hindu Adoption and Maintenance Act deals with the legal adoption of children by Hindu and other legal obligations that follow, including maintenance of children, wife, and in-laws. In the first part of this article, Hindu Adoption and Maintenance Act was enacted in the year 1956 and came into effect on December 21, 1956. Applicability of Hindu Adoption and Maintenance Act. As per the Act, a Hindu does not merely mean a person that follows Hinduism but also includes other sub-religions of Hinduism, such as Buddhists, Jains, Sikhs, Virashaiva, Lingaya, or members Arya Samaj. Followers of Brahmo and Prarthana are also included in the definition of Hindu. As a matter of fact, the Hindu Adoption and Maintenance Act covers everyone residing in India who is not a Christian, Muslim, Parsi, or Jew. The Act sheds light upon what a valid adoption is. Who can adopt children? Procedure to adopt children along with other duties and obligations that occur after adoption. What is adoption? The Act has no description of the word adoption, but it is a Hindu law derived from uncodified Hindu laws of Dharmasastra, specifically Manusmriti. Adoption has been described in Manusmriti as taking someone else's son and raising him as one's own. Hindu Adoption and Maintenance Act has made the definition of adoption much wider by using the word child instead of son. Child includes both a girl and a boy child, and not merely a son. With the change in society over time, a codified and uniform legislation was required to serve the democracy, so no adoption can be made without the procedure mentioned in this Act. If any adoption is made neglecting this Act, the adoption shall be rendered to be void. Adoption will be valid only if it has been made in compliance with this Act. Who can adopt a child? In order to adopt a child, the person must be a Hindu and have the capacity to adopt it. A Hindu male who wishes to adopt a child must meet the requirements provided in Section 7 of the Act, and a Hindu female wanting to adopt shall abide by Section 8 of the same. The capacity of a Hindu male to adopt. Section 7 states that a male Hindu who is willing to adopt a child must fulfill the following conditions: attain the age of majority, and be of sound mind. He shall not adopt any child if he has a wife living at that time, except with her consent, unless and until the has renounced the word or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. If a person has multiple wives, the consent of all the wives is necessary for adoption. The capacity of a Hindu female to adopt. Section 8 of the Act states that a Hindu female willing to adopt a child must fulfill the following conditions: have attained the age of minority, be of sound mind, be either a widow, divorced, or unmarried in order to adopt. If she has a husband who is alive, she will not have the capacity to adopt a child. Person capable of giving in adoption. The parents and guardian of the child can give them up for adoption as per Section 9 of the Hindu Adoption and Maintenance Act. As per the Act, only the biological father of a child has the authority to give him up for adoption. The consent of the child's biological mother is necessary. A mother will have the capacity to give the child up for adoption if the father is either dead, of unsound mind, has renounced the world, or converted to some other religion. The section clearly mentions that the father and mother mean biological parents and not adoptive parents. Adoptive father or mother cannot give the child up further for adoption. Can the guardian give a child for adoption? A guardian, as described in Section 9 of the Act, means a person appointed by the parents of a child or the court for taking care of the child and his/her property. If the child's biological parents are either dead, have renounced the world, have lost their mind, or have abandoned him, he can be given up for adoption by the guardian. But in order for a guardian to give up a child for adoption, he must have the permission of the court for doing so. Person who may be adopted: he or she is a Hindu. Has not already been adopted. He or she has not been married unless there is a custom or usage applicable to the parties which permits person who are married being taken in adoption. He or she has not completed the age of 15 years unless there is a custom or usage applicable to the parties which permit person who have completed the age of 15 years being taken in adoption. Effects of adoption. Adoption will completely change the life of a child in many ways. he becomes a part of a new family and will have rights in the property as well. Section 12 of the Act states, when a child has been adopted, they shall be considered as the child of their adoptive parents for all purposes. The adoptive parents shall have all the parental obligations and rights. The child shall have all the rights and obligations of a son/daughter. However, there are some conditions that the child must abide by after he has been adopted, such as he/she must not have an incestuous relationship with anyone from their biological family, and should not marry anyone from their birth family. The rules of the Hindu Marriage Act, 1955 regarding Sapindar relation shall be applicable to them towards their birth family. The adopted child shall not deprive any member of his birth family of any property that he held before the adoption. Rights of adoptive parents to dispose of their property. If adoptive parents wish to dispose of their properties by transfer or by gift or will, they are free to do so and adoption does not stop them, unless there is an existing agreement that states the contrary. Valid adoption not be cancelled. No adoption which has been validly made can be cancelled by the adoptive father or mother or any other person, nor can the adopted child has any right to renounce their adoption and return to their biological family. Prohibition of payments. With the increasing child trafficking around the world, the prohibition of payments during an adoption is one of the most important rules in order to ensure that the child is not being sold. It is stated in Section 17 of the Act that no payment can be received or made during an adoption by anyone. No one shall receive any reward in monetary or non-monetary ways for adopting a child or giving them up for adoption. If one is caught making or receiving payment in any form during the process of adoption, they shall be liable for imprisonment for up to 6 months and/or fine. Thank you for watching. Please support us by subscribe our YouTube channel and do not forget to like the video and it anyone have any problem related to any topic then they can tell us in comment section below.